Be ready for the dictation. 5, 4, 3, 2, 1. Start. This appeal challenges the judgment and order dated 21st December 2013 passed by the High Court of Punjab and Haryana in Criminal Appeal number 1793 of 2011 confirming the conviction and sentence of the appellant and 1 Jaswant under sections 398 and 401 of the Indian Penal Code and section 25 of the Arms Act. On 18 December 2014, this court was pleased to issue notice limited to the question of sentence. According to the prosecution, the police had received specific information that the appellant and 1 Jaswant were planning to loot passing vehicles near gas agency store situated in Sector 21, Faridabad. This information was received on 9 February 2009 after 9:30 p.m. PW to Ishwar Singh. ASI was already present in Sector 21, Faridabad on patrol duty. On receipt of the information, he along with raiding party proceeded towards the spot. According to PW to Ishwar Singh and PW4 head constable, they saw a white-colored car parked at a deserted spot. They further saw that the appellant and said Jaswant tried to stop a passing Maruti car, but the driver evaded them and sped away. The police overpowered the appellant and said Jaswant and on their personal search recovered a knife from the appellant and an iron rod from Jaswant. On search of the car, the police found 2 number plates, one having car registration number of Madhya Pradesh. The photographer was called and photographs of the vehicle and the site in question were taken. During investigation, it was discovered that said car was actually owned by LIC and was a stolen vehicle. Neither the appellant nor said Jaswant could come up with any explanation how that car was found in their possession. Further, both these persons were residents of district Gonda, UP and not residents of Faridabad. The trial court, after considering the material on record, found that the case as against the appellant and Jaswant was fully made out. It convicted both the accused under Section 398 IPC and sentenced them to suffer rigorous imprisonment for 7 years. They were further convicted under Sections 471 IPC and 411 IPC and sentenced to suffer rigorous imprisonment for 7 years and 1 year respectively with imposition of fine and sentences in default. The appellant was also convicted under Section 25 of the Arms Act and sentenced to suffer rigorous imprisonment for 1 year. In appeal arising from the judgment of conviction of trial court, it was submitted that both the accused had already undergone custody for over 3.5 years and that their sentence be reduced to that already undergone. The High Court considered the matter in its entirety and found both the accused were armed with deadly weapons and that the record showed that they had other pending cases registered against them. The High Court thus did not differ from the view taken by the trial court and dismissed the appeal. We have gone through the record and heard rival submissions. As mentioned herein above, notice was limited to the question of sentence. The conviction in the instant case is under Sections 398 and 401 of the IPC. Though sentence under Section 401 can be less than 7 years, that under Section 398 shall not be less than 7 years. The appellant and said Jaswant was sentenced to 7 years rigorous imprisonment under Section 398 IPC.